Hello, everyone. My name is Femi, and I have with me Philip. And welcome to Law in Depth. This podcast, this is where we break down legal issues affecting everyday lives. No lectures, no legal jargon, just the law explained straight.
So today's episode asks a simple question, but the answer might surprise you. When does your employer actually have to pay you if you get injured? Maybe more interesting, when do they get away paying nothing?
Okay, imagine this. You are at the office Christmas party. Music is playing, food, free drinks, your boss is dancing like nobody's watching. And then suddenly you fell from a poorly lit staircase, broke your ankle, hospital trip. The big question is your employer responsible? And here's the twist. Sometimes the answer is yes, and sometimes it's absolutely not. And sometimes even the High Court of Australia struggle to decide.
Here's what the law says. Under the Workers' Compensation and Injury Management Act, 2023 in Western Australia, the rule is simple. If your injury arises out of your employment or happens in the course of your employment, you can claim compensation.
And this compensation actually includes work injuries, diseases caught because of your job, aggravating an existing injury, some psychological issues. Think about nurses, paramedics, NDIS workers. They deal with this risk every day.
But here's where it gets interesting. The law also says that some things are not covered. For example, you've got your travels to work and from work. You've got psychological, psychiatric conditions arising from disciplinary actions. And then you've also got performance reviews, dismissals, that sort of thing, not covered. And then there's a big gray area, which are activities around work.
Let's start with one of the most famous work injury cases in Australia, and that's I'd say Manolis v. Annie Corporation. This case actually changed the law.
So here's what happened. Worker was stationed at a remote mining site. Because the job was remote, the employer provided it during the time off, and he went sightseeing with another worker.
Boom, car accident, serious injury. The company said, not our problem, it was off duty.
I said something very different. He said, if your job requires you to live somewhere off-site for work, and injuries during the breaks between work shifts can still count as work injuries.
Now, lawyers call this the interval doctrine. Basically, what they're saying is if you put someone somewhere, the employer must still carry the risk.
Now, let's talk about a different case that broke the internet's legal circles. And this is the case of Comcare and PVYW.
Now, a public servant was on a work trip, staying in a hotel paid for by the employer. While he was in the room, he was injured during a sexual activity because the lighting fitting fell off.
So after knocking the books, this worker claimed work comp. And what was the argument? I was injured during a work trip.
The High Court said, not so fast. They created a new rule essentially, and they said for injuries during work travel, the employer must have encouraged or induced the activity that caused the injury. Emphasis on encouraged and induced the activity.
So in essence, in this instance, it can't be said that the employer encouraged them to engage in their night activities. And so in this case, the employer wasn't responsible.
Now, let's talk about assault at work. Now, it gets a bit darker. What happens if you're assaulted at work?
In authority, of Westrock and BIS Industries. This is a WA authority. This worker living in a mining camp, and he decided to grab a tire. Another employee assaulted him.
And then the employer argued he was having a beer, so they're not liable.
But the federal court said something important. They held that the tavern was part of the facilities provided to the workers, and effectively they held it to be part of the work environment.
So the worker received compensation at that time.
Right.
End of story.
Yeah, quite so. So let's deal with another case that also involves work travels. In this case, this matter involved a lady called Michelle Blanche, and it's a Queensland authority. So she had traveled, she was an air hostess and traveled to Los Angeles. She was working for Qantas, and she decided, let me just go for a walk.
And in the course of walking, there was a cyclist around, and the cyclist hit her. Serious injury happened.
Yeah, and so this happened during her free time, and the court decides that if your work requires you to be in another city, normal activities like walking, getting a lunch, can still be held to be related to your employment.
Yeah. So the kicker here is the judge said essentially, if not because she was posted to Los Angeles to work, the cyclist would not have hit her. So compensation approved.
That's right. Now for another bizarre case, this is the drunk roommate case. Another leading authority, similar to the first case that she saw. And in this matter, there was a worker who was sleeping in shared accommodation, and his colleague came home drunk and ended up literally taking this on guard. And yeah.
So he sued, arguing injury happened because of work accommodation.
Yeah, the High Court said, no, you're not going to get any compensation from your employer, and reckoned that the connection to the employment was too weak. So this is basically somebody taking advantage of the opportunity during the employment. Company provides that opportunity and encourages activities, then you can be held liable. But then where somebody just takes advantage and does that to you, you're not going to get any compensation from your employer. The court in this instance was a bit divided, but it kind of tells you that this is a bit of a gray area. Yeah.
What does this tell us, essentially? The court usually asks 3 questions. And before you came to the question, Phil, I would just say in subsequent episodes, we will sit down properly and break down all these cases, because there were a lot of lessons that we need to learn from all these cases. We will be breaking this down in the course of subsequent episode. So please stay tuned. And now back to what the questions the court was asking. It's 3 questions basically to determine if your employer is going to pay or they're not going to pay. Still, what do you think?
Yeah, so I think the first question that the court asks is, did it happen in the course of employment?
And was the job a significant contributing factor to the activity?
So the injury happening. And then
Injury.
so the third question, which is what I was talking about before, is whether the employer created, encouraged, or did they control the situation that led to injury. Another way that this also has materialized is in Christmas work parties. The few cases that we're going to discuss that sort of deals with this, slipping and falling outside the bathroom, public bar area during a work-related trip, and the court says no, that wasn't because of your work. You've just slipped, and because sometimes even the time of day might affect the ruling of the court, where they decide whether your employer is going to pay or not. If you fall at 2 a.m. in the morning, no compensation. 7 a.m. in the morning, you might be entitled to compensation. So, yeah, back to you.
So to summarize the question again, one, was the job a contributing factor to the injury? Did the employer create, encourage, or control the situation? Or did it happen in the course of your employment? If the answer is yes to all these questions, compensation may follow. Workplaces are changing. Remote work, FIFO jobs, travel, international travel, which means the line between work life and personal life is getting thinner.
And it's that thin line sometimes could be worth hundreds of thousands of dollars, if not millions. And I think in the next episode, we'll tackle something even more controversial, which is psychological injuries at work. PTSD, bullying, stress claims.
Yes. And until then, this is Law in Depth, where we unpack the law. Stay tuned. Goodbye. Thank you.
Bye.
Cheers.